So,
It's 10:11 at WPSL 1590, the Talk of the Treasure Coast, and through the mastery of Comcast Live, here's Stuart Address. Hey there, fella.
turn on your camera.
My goodness, you need to feed those animals at Comcast at your house.
Well, that's true. Comcast has not been very nice to me at the office. I can't access it. So I didn't have the meeting coordinates for this meeting. I was locked out of my own show and your camera still isn't on, so I can't see your lovely face and interact off of you. Turn on your camera. For the rest of you folks, I'm Stuart Address and this is Ask a Lawyer for January 7th, 2022, even though it'll be 5 minutes or so abbreviated. But hey, that's good news, right? And I can see you. All right, so look, last week we were still talking about catfishing and online dating, and I do intend to finish that topic. But I wanted to touch a little bit on another topic before it becomes stale. And that's, seriously, can a New Year's resolution be dangerous? And can you sue for breach of a New Year's resolution? Bet you never really thought about that now, did you? Making all those crazy promises that you know you can never keep. Well, let's just see how much trouble it might get you into. There are a number of types of New Year's promises, often there to make some incremental improvement in your life. However, when picking up a new hobby, you may be exposing yourself to unknown hazards. Now, whether you make a promise to yourself to spend more time at the gym, go on runs more often, pick up a hobby like yoga, the possibility of injury is ever present. So let's take a look at a few common New Year's resolutions and how they can end up in disaster. All right, I'm going to go to the gym more often. Great resolution. It's perhaps the most common New Year's resolution, getting into shape. I know I've promised it several times, but whether you make the promise to yourself to spend more time at the gym, go on runs more often, or pick up a hobby, you have to be prepared because gyms are full of potentially dangerous equipment that, when improperly maintained, can cause serious injury. Of course, gyms and fitness clubs are responsible for maintaining a safe environment and can be held liable for their failure to do so. What's the point? You make this New Year's resolution to keep yourself fit, you go to the gym, you hurt yourself, and it's the gym's fault, not keeping the equipment in good running order. You can sue and you could probably recover, but your New Year's resolution brought yourself an injury. These are sort of half facetious. I mean, I wouldn't say don't go to the gym, but I would say be careful like in anything else you do. Similarly, run more often. Running's a great way to get into shape. I don't think I would know about that for quite a while. Last time I ran, 20th century. Anyway, but unless you buy an expensive treadmill, you'll likely need to run outside. Many runners prefer to head out early in the morning or late at night when the roads are less busy. However, especially during the winter months, not so much here in Florida. This is when it's also the darkest outside. This can put you in danger of being struck by a driver who's not paying attention. Another problem, personal injury. What about, a good one for me? I can't imagine being able to do this. I know there's somebody who would disagree, but pick up yoga. Imagine me trying to stretch my arms and my legs. Many who practice yoga find that it provides them with both a physical and a mental workout. Yoga studios offer a range of classes geared towards beginners to help them learn the practice. However, like a gym, there may be hidden dangers in a yoga studio. Some of the most common hazards involve wet floors, defective equipment, and instructors who recommend poses that are inappropriate for beginners. Now, I was researching this a little, and the part here where it says defective equipment, is there somebody out there who can explain this to me? I thought in yoga you were on a mat. I mean, is there other kind of equipment? Because I don't know how the mat can hurt you. Maybe somebody who does yoga can call in and explain at 340-1590, or for any other reason. It's better than me hearing myself talk. What about a New Year's resolution to travel more? Oh, is that dangerous right now, boy? Given the fact that many of us have been locked up at home far more than we'd like to, traveling is likely to be a common New Year's resolution. Did you make that resolution? Whether it is by car, bus, or airplane, I'll add, or train, all forms of travel pose certain risks. Travelers should be aware of these risks as well as what they can do to recover compensation from responsible parties in the event of an accident. Now, I'm going to amend this on my own from the research I did. Given the coronavirus, whether we're at variant A through Z or if we end up getting to double Z, okay? You have lots of issues with trip cancellations. Can you recover the price you paid in the event of a trip cancellation? Well, that's where these very often available, particularly on cruises, trip cancellation policies come into play. First of all, I would say now more than before, you should probably get trip insurance anytime you can. But before you just purchase it, read it. Read it. I said, read it. You need to know things like, is coronavirus covered or excluded in the policy? Are acts of God covered or excluded? Has the policy been written in a way that takes into account the virus and works to the advantage of the insurer, not you, the insured? These aren't very long policies. These aren't like, homeowners policies that have 18 endorsements. These are things you can read. And you really need to read them before you buy the insurance, because worse than not buying the insurance would be buying the insurance, being in, I don't know, let's just say Colombia, finding out that the cruise has to end and you need to fly home, and you don't know whether or not that's going to be covered by the cruise line. Is it going to be covered by insurance? Do you have to pay for it out of pocket at your own expense? The worst thing is your own expense. So know what you're getting and not getting if you buy insurance. And if the insurance covers it, definitely get it. Because these days we never know when the decision will be made by each one of us individually that it is simply too unsafe to go. Now, I'll give you my situation. Obviously, I got married 12 days ago. Still counting days.
And you're still married.
We're still married. I love her more today than I loved her on day one of the wedding. There's some facetiousness there, but there is a truth there too. Really, it is funny. I'll tell you all, God, she may kill me for this, but we've lived together for 2 years. So one would think we didn't get to go on our honeymoon because the cruise line canceled it. And so one would think that we went back home, and what could be different? I mean, it's the same old, and it is. but they say that the piece of paper does something. I haven't even seen the piece of paper yet because the clerk has not yet filed it. But it does do something when that paper is executed. You are bound together in a way that you weren't before. And yes, I do look at her differently. I feel the same, but I feel different. And so does she. So that's a good thing. In any event, if you made a New Year's resolution or ever intend to, think about it and just think about whether or not it could be dangerous and whether or not, if it is, you can sue for it. Now,
Well, I've got a question though. If the courts never process your marriage certificate,
are we really married?
are you really married?
Well, okay. First of all, we know the clerk is backlogged. So I'll see it sooner or later. Well, the rabbi said she dropped it off. Ask the rabbi when she shows up for her show. If, let's say, the clerk loses a marriage license that's been filed, it's the only copy, what happens? I would dare to suggest that if I did my research, I would find something like, as long as you can prove the marriage, have an officiant attest to it under oath, they would accept that as a substitute document, particularly here in a religious marriage. We also signed a religious contract, a ketubah. We signed that before the actual ceremony. And under Jewish law, as the rabbi could verify, if you called ask a rabbi, immediately following ask a lawyer, as the rabbi will verify, once we and the witnesses signed the ketubah, we were legally married. Not in the eyes of the state of Florida, but in the eyes of Judaism. And so the service that proceeded outside was to meet civil requirements of getting married. And so if that certificate is lost, I think we would be able to what's called reform it, which is to recreate it by other means. Does that answer your question, Greg?
Yep, got it. And you got one more here. Charlie
Okay.
calling. Go for it, Charlie. You're on with Stuart.
Hello, Charlie.
Stuart, congratulations that you got married.
Thank you very much. I appreciate it.
Yeah, we spoke once before. I'm the gentleman with the prenup.
Oh, another prenup. Okay.
Yeah, and you have one too.
Now I do.
I've been with my now wife, got to be 20 years, and we got married about 5 years ago.
Okay.
And
You waited a lot longer than I waited.
it changed my attitude and so forth. I now wear a wedding ring and that type of thing, and I love her. She helps me.
Well, that's all good.
Happy with your wife? You said you're very pleased.
Yes, I'm very happy. She's truly a wonderful person. She treats me lovely. And Charlie is telling us, for those of you listening on Facebook, that he was with a woman for 20 years and got married about 5 years ago with a prenup. And he looks at her different. It is different, and they're very happy. And that's good to hear.
And you talked about cruising, right?
Right. Yes.
Have you ever been on a small ship, Stuart?
How small are we talking?
How far? Well, I booked a year from now, December 27th.
Okay.
Went on Silver Sea with my wife, and it's a 9-day cruise, and it's I get to do some scuba diving, but it's like 500 passengers.
Oh, 500 passengers. That is indeed a small ship.
It's like it'll be Port of Everglades to Port of Everglades. I had booked a cruise on Seabourn in Europe, and
A very, very nice cruise line.
The COVID business,
Right.
you know, it's
Yeah,
very
Seabourn is an upscale cruise line.
cool.
Go ahead.
All right, Stuart. It's good to talk to you. And
All right. Thank you, Charlie, for calling in.
God bless America.
Thank you. God bless America. Absolutely. Well, Charlie's also planning a cruise in December of 2022. For his sake, I hope he's more right than I was December of 2021, that this would be over by now, or I'd be on a cruise right now. I don't know on which port, but I'd be on a cruise, 2-week cruise.
Yeah, and you just hope it's not on the Titanic too.
Well, that is true, not on the Titanic too. Although it might be fun to go on a Titanic too and see whether they learned anything. I would take as much life insurance as I could get.
Well, you know, I just saw a television commercial for the brand new cruise line, Virgin Cruise Lines out of
That's right.
Miami. Yeah. Branson's doing it again.
Where is Virgin going?
All over the
There are a
place.
lot of guys who'd like to meet her.
Yeah, that's right.
You know, folks, cruise ships are called ladies, they're hers. So yes, there are a lot of guys who would like to meet the Virgin ship.
No comment.
Okay, Greg, I know. Better, safer, better that way. All right, so returning to the New Year's points, let me give you some serious tips so that neither you nor some other party gets in trouble. If your New Year's resolution involves anything businesslike, you want to make sure you avoid litigation. You want to make sure you don't have to ask a lawyer. And then if you do ask a lawyer, you give the right answers. Not only do you get the right answers from the lawyer, but you give the right answers so the lawyer can give you the answers you want to hear. First, if you don't write it down, it never happened. Oh, yes, you can testify about oral agreements and promises and consideration. By the time you finish spending your attorney's fees on trying to prove oral agreements, it doesn't matter whether you recover. I'll have been the winner. Put it down in writing. Confirm by email. Memorialize everything. I know it seems like a pain in the tuchus, but I always ask prospective clients, did you send an email? Did they confirm? Do you have something that memorializes this conversation you had? Because let me tell you why that's important. You have a conversation with somebody and then you send them an email, to summarize what we discussed. And they never respond. They never disagree with what you said. If it comes to litigation, a court or a jury is likely to believe that you accurately summarized because they never objected. So it is very important to write it down. And it doesn't have to be a novella, just a summary, bullet points. 2, don't be that guy. Be flexible. When you can, go the extra mile. In my experience, many lawsuits get started because both sides start out seeing the other as unreasonable. Sounds like our current state of politics. That doesn't mean you should let people walk all over you. But when someone comes in with a complaint or a problem about the deal, listen, you both may be able to solve the situation with both of you getting what you want. The proverbial story is both women want an orange for their dinner cooking that night. And there's only one orange left in the store. Not so hard to believe these days, is it? And they both grab the orange at the same time, and now they're arguing about it. And the store manager comes and in a Solomon-like way says, I'm just going to cut it in half. You can both pay for half an orange. And that's what happens. Turns out the women meet up again the next week at the grocery store. and are a little bit more polite this time and ask each other how their dinner went. And one woman says, well, not as well as I hoped. The whole orange peel would have helped me much more. And then the other woman replies, oh, I didn't need the peel, I just needed the juice. Well, if they had both communicated with each other originally, they both could have been fully satisfied. One would get the peel, one would get the juice. But because they fought over it and immediately decided the other was being totally unreasonable, and they wouldn't listen, they both lost. And that is a very, very true moral of the story. Really. Go into mediation at any time, and you're going to hear this story over and over from the mediators. You need to listen. Very hard thing to do when you're fighting over something. But you need to listen to what is the other side's needs. And if they listen to yours, there may be a way to make most of you mostly happy. So in addition to not being that guy, I cannot tell a lie. Be honest. Again, not like most of our politicians today. Little white lies in social settings are one thing. But in a business agreement, even if you're the customer, and especially if you're the employer, you own a business, one little fudge turns into another and another. If there is a problem from either end, fess up and work it out. Don't hide it or blame. I have a consultation in about a week with a person who's not happy with the installation of, I think it's an outdoor storage roof above their home or something, above the patio. And they're getting nowhere with the contractor. So they're gonna probably hire me to write a nasty letter. If I need to, yeah. But if I can figure out what is needed by the client and what is wanted by the contractor, maybe there's a way to use honey rather than a nuclear weapon. And if you work at it, sometimes you can really hold off on any lawsuits.
Oh, I've got a great promo for you.
Yeah, go ahead.
Just the promo opens up with a nuclear bomb. Stewart address, your nuclear lawyer. That may be slightly in bad taste, but
I don't believe the Florida bar would approve it. For Facebook, Greg saying he sees a new promo for me. A mushroom cloud explosion. And then Stewart address, your nuclear lawyer. I like it. I don't think the bar would.
no, I don't think so.
Now, next little tip, we only have a couple more and then we'll go back to dating and online dating. How much fun can that be? Neither a borrower nor a lender be. Sometimes you have to, but minimize it. And above all, don't take on or give more credit to someone who hasn't settled the prior account. If you are the borrower, you are getting yourself deeper in. If you're the lender, you're increasing your risk of loss and of a lawsuit. So when the stakes get high, you need to remember what Shakespeare said. Loan oft loses both itself and friend. Anybody know Shakespeare who can help me interpret that better? Better than simply, if you borrow or loan to your friends, you're likely not to have the friend later on. All right. Don't be a stranger. You don't call. You never write. Bubby said. Well, stay in touch. It's psychologically easier to sue a business than that nice lady at the restaurant, hair salon, repair shop. Something as small as a holiday card can make it a human relationship. So problems are worked out in person and not in court. So all these crazy, as they would say in Yiddish, verkackte New Year's resolutions. They can be fun, but depending upon how far you take them, they can be serious. And if you make a New Year's resolution that is more in the nature of a contract, and you receive back consideration, you may have an enforceable contract. Be careful. Be careful. All righty. Enough with New Year's. It passed a week ago. Let's see. Jewish New Year will be coming up in about 9 months. Real New Year will be coming up in about 12 months, 53 weeks. So let us return ourselves to discussion of online dating and fake and misleading profiles and what is generated as a result of those. And let's start by recalling, if you were listening last week, what we've done so far. We've gone through outright lies and exaggerations, which are common on internet dating sites. We've also gone through some of the US government lawsuits against the larger sites, like all the sites that are owned by Match.com. Trust me, Match.com isn't just Match.com. It's like 7 or 8 other sites it owns. I'd have to go pull, Greg is looking at me with googly eyes. I'd have to go pull the list, but Match.com owns a lot of these. I don't know which ones offhand, but let's say like Our Time for 50 and over, or I don't know, maybe Christian Mingle. Again, I'd have to look to see who they really own. But a lot of these smaller, more focused sites are owned by Match.com. We've even discussed a Flagler County, Florida lawsuit that arose from a false online dating profile and resulted in a sexual assault. And that case is still pending during discovery. So we come to a question I've heard asked regarding whether catfishing is illegal and whether you can sue someone for fibs, falsehoods, lies, and other scams resulting from online profiles. Well, there are a lot of answers to that. Is catfishing illegal? The Urban Dictionary defines catfishing, just so we're all clear, as the phenomenon of internet predators that fabricate online identities and entire social circles to trick people into emotional romantic relationships over a long period of time. Possible motivations being revenge, loneliness, curiosity, boredom, and financial. That's catfishing. One illustration would be someone who is in an internet-only romantic relationship over an extended period of time, and he has said he loved her, wants to marry her, and it turns out the woman he loves and wants to marry never ever existed. The person he was talking to was lying to him. The photos weren't of her. She was not single and in love. Rather, she was married with 2 kids and didn't look anything like the woman in the photos. That's an illustration of it. So the legal question becomes, whether the perpetrator can be sued by the target victim for catfishing. And in essence, is it illegal to do that as part of an online dating profile, which is a little bit different than simply lying. Okay? Catfishing has an intent. It's deception amplified by the internet. And the answer to the question of whether it's illegal, whether you can sue for it, like most legal questions, is that it depends on the circumstances. The law is gray. There is very little that's black and white, which is why Democrats and Republicans should be able to agree on some things because they can meet in the gray where they used to meet. Now they're on the fringes of right and left into the black and white. Just my little political comment for the day. In most cases, being lied to is not actionable. In other words, generally, you cannot sue for being the victim of a lie. He lied to me that he had brown eyes. Yeah. He lied to me that he was a professor. No. He lied to me that he was 6'4". No. She lied to me that she was 120 pounds. No. So we're looking at something more. In catfishing, we're really looking at a deception, a whole complete deception from the beginning, with the intent of accomplishing one of the goals that we had mentioned. But for the most part, catfishing probably would be criminal. There might be a civil claim. And so let's transition then to what occurs more frequently.
How about if she takes your bank account?
Well, that's theft. That's false identity, taking a bank account, things like that. What happens more often, and we discussed this last week, is almost everybody embellishes on a dating profile. The statistics were about 80% of dating profiles are not 100% accurate. And it was even among men and women. So a little, putting your best foot forward is not to be unexpected. The question is, when does it become material as a legal term? When does it become important, valuable, to whether you would be interested in continuing had you known? So people who watch TV and movies and others have asked me about something they have heard about: intentional or negligent infliction of emotional distress. Can I sue for infliction of emotional distress? When I heard who he really was, I was so upset that I had to go to counseling. I had to get medication. Can I sue? Well, let's explore that. Both intentional and negligent infliction of emotional distress. To state a claim, you have to prove 4 things. 1, deliberate, reckless infliction of mental suffering. 2, outrageous conduct. We're going to circle back to that one. 3, conduct caused the emotional distress. And 4, the distress was severe. Now, the 2 that are really key to me are outrageous and the distress was severe. The law wants to winnow the number of cases that are filed for emotional distress. So you can't go in because it upset you. It made you cry. It's not good enough. That's not significant distress. And outrageous conduct, The way the courts in Florida have defined that is conduct that is so utterly and totally abhorrent that one, upon hearing it, would proclaim, that's outrageous. Not that awful, but that's horrible. But that's outrageous. Conduct that cannot be permitted in a civilized society. That is a tough element to meet. Because while there are so many things that you can say casually are outrageous, if they're common, then they're not outrageous. If they're done all the time, it's not outrageous. It's that thing that is done that is so unexpected, so collapsed to the ground, that will likely get you finding that it was possibly outrageous.
So where do you get your expert witnesses?
Where? From what source?
Yeah. Who is an expert witness in a case like that?
Well, I would get it from the expert witness fairy box, where you open it and you ask for the appropriate expert witness.
Well, if the expert witness was a shrink, it's not legal for them to divulge medical information, right?
Well, it is if you're the one putting the shrink on to testify to the conduct, or you put on a sociologist to testify to conduct, let's say, and a shrink to testify to how it impacted you. But I'm going to give some real harsh examples of how the Florida Supreme Court has so narrowed the tort of intentional infliction and the tort of negligent infliction, so that they almost don't exist in Florida. So you really have to prove outrageous, and you really have to prove emotional trauma in Florida. And we're going to get to why that is. So if you live in Florida, my advice would be, don't get so excited. Given the actions of our Supreme Court, it's going to be really hard to sue under one of these doctrines, although others in other states probably can. Here's an example of something that was deemed outrageous. A circuit court in Florida, there was a 14-year-old boy who died of an apparent drug overdose. Police officers considered that the death was possibly suicide or homicide. During the boy's autopsy, police officers took photographs and videotaped the procedure to assist in the investigation of the death. Perfectly proper thing to do. The next evening, several officers viewed the photographs and video at the house of one of the officers. This is the first hint that something is amiss. Why are they viewing it at the house of an officer instead of in the police department? Well, a newspaper article that was published described the viewing, quote, as having taken place in a party atmosphere where the audience joked and laughed. Well, we got a little bit of a problem here. All right, the boy's mother and sister sued on various theories, including intentional infliction of emotional distress. The Florida Supreme Court held. Several Florida cases have held that even where the requisite outrageousness occurred in the defendant's acts towards the original victim, the emotional distress felt by close relatives of that victim when they learned of the acts was not actionable if the relatives were not present during the acts and the defendant's conduct was not directed at them. Okay, so here comes one of the problems that the Florida Supreme Court sees. This happens to you sue, that's one thing. This happens to you and family members are upset. Well, okay, yes, they're upset. But the courts decided that that level of upsetness is not going to satisfy the fourth element of severe harm. It may if you're the victim, but not if you're a relative, except in a very narrow exception we're going to discuss. So the court does that to minimize the number of lawsuits and the number of claims, because in various cases, the court discusses being burdened by thousands of such cases being filed, and it being difficult at the very beginning to determine which ones are frivolous and which ones may have merit. So the court has set up boundaries. It's just that the boundaries are very narrow for most lawyers' satisfaction. All right, so in general, under Florida law, the court will allow a lawsuit for emotional distress to proceed where the defendant's shocking and scandalous acts occur in the following two situations: upon children and upon families. On children, the Florida District Court of Appeal in Corbin versus Berlin in 1965, a long time ago, still good law. A 6-year-old girl's guardian alleged that the defendant approached the girl, represented that the child's parents had committed adultery and would be punished for it. The plaintiff alleged that the statements were knowingly false, made in utter disregard of the feelings of the 6-year-old, and for the purpose of causing her mental pain. The Court of Appeal held that a cause of action would exist if the alleged statements were communicated to the child, but not to the family. Okay. Now, let's get closer to what would be okay for the family to sue on. Where the defendant intentionally causes emotional distress and the defendant has mishandled a body after a family member's death, they can sue for intentional or negligent infliction of emotional distress. Very narrow, I think you would all agree. Not going to happen very often to you, not likely something you have to worry about. But there's a slightly larger exception, which hopefully nobody has to be ever involved with, and it's certainly not an issue in online dating. It's called the zone of danger. Evil music playing in the background. All right, where the person suing for emotional distress does not necessarily need to be harmed themselves. Florida law will permit recovery for emotional distress in certain circumstances where the individual is merely in the zone of danger. What does that mean? Well, Florida has what's called the impact rule. This means that for a claim of emotional stress to be successful, the claimant has to be physically impacted in some way. Well, that means it's likely to fail if you were never touched or harmed. However, the essentially means a garden variety type emotional distress claim. There is an exception, which is the relative bystander test. A plaintiff can recover emotional distress damages caused by someone's negligence if the victim's severe emotional trauma also caused the plaintiff physical harm, such as a heart attack or a stroke. but only if the plaintiff had a close personal relationship and they witnessed the event that caused the loved one's injury. So the example that's always used, the car driver sees the girl in the street, doesn't make any effort to avoid her, hits her, kills her. The mother on the porch is screaming. The mother has a claim for intentional or negligent infliction of emotional distress. She was there, she saw it, it caused her really serious harm for life. That's about as narrow as the Florida court wants to go. But if it's just that the defendant has acted recklessly, you're not going to have a claim for just psychological injury. There has to be some physical impact. Now, there's another, we have 2 minutes. There's another exception, which is a good one. It's not intentional or negligent infliction of emotional distress. It's fraud. And that is a larger topic that we can talk about next week. But if somebody has lied to you significantly, they have to have knowledge that their statement was untrue. There has to be a false statement of material fact. There has to be injury, emotional or otherwise, to somebody. And it must have been reasonable for you to rely upon what they were saying. Now here we have a question. Is it reasonable to rely on what they're saying in an online dating profile? That's an interesting question. So, I will sort of wrap it up here because it doesn't pay to continue on right now. But online dating is a great thing. I think it's a great thing. I've been part of it since it started, and maybe even before it formally started. And I'm certainly part of it in meeting my wife. But there are dangers, and you should be aware of them. Anyway, that music means they're pulling me off the stage or out of my seat. And so for Ask a Lawyer, I'm Stuart Address. Have a safe weekend, a safe week, and I will talk to you next Friday.
Stuart Address from Fantasy Island, the world of online dating. Right here on WPSL, Port St. Lucie, talking to Treasure Coast and WSTU.
Greg says, Stuart Address from Fantasy Island. There's a ring to it. I'd like to go to Fantasy Island so I can have a honeymoon and not have to worry about the coronavirus and Omicron. So, well, they logged me out here, and I turn